But my name is Amanda Maya. I'm a senior attorney in the Kind San Francisco office. And today we are going to discuss kind centered strategies to develop the record for family and gender based violence claims in immigration courts.
And I'm America Hernandez Lemos. I'm a social services program manager national at Kind. And I'll get us started with our agenda.
Ne-
So we'll walk you just briefly. As you can see, we have a pretty full agenda. First, we'll talk a little bit about Kind. We'll go through a hypothetical. We'll talk about trauma and its effect on unaccompanied youth, the importance of trauma informed lawyering, and then provide a legal framework for family and gender based violence claims.
We will also discuss the compilation of evidence required for merits hearings, client centered strategies when working with experts, client centered strategies in preparing the client to testify, advocating for unaccompanied children in immigration court. And if we have time, we definitely want to do a Q&A session. Next slide, please. So let's start off first with KIND's mission. So KIND stands for Kid in Need of Defense, and we are focused on ensuring that no child appears in immigration court without high quality legal representation. We work on advancing laws, policies, and practices that ensure children's protection and their right to due process. And we promote in countries of origin durable solutions to child's migration that are grounded in the best interest of the child. Next slide, please.
We also have 4 programs at Kind. As you can see, we have our legal programs, our psychosocial programs, our global programs, and our policy and advocacy. And leveraging its multidisciplinary teams and their skill sets is key to ensuring that Kind clients receive robust, child-centered, trauma-informed, and culturally responsive legal representation, psychosocial support, and advocacy. Next slide.
So now we're going to discuss a hypothetical, and we're going to reference this hypothetical throughout the presentation. But before we get to it, I do want to provide a trigger warning because this presentation does include subject matters related to trafficking, sexual, emotional, and physical abuse. And as we reference this hypothetical, we'll talk about ways in which I supported Alexandra and also ways in that we could support a client who has a similar experience to Alexandra in her immigration case. Next slide, please. So let's go through the hypothetical. So Alexandra fled Guatemala when she was 13 years old because she was sexually trafficked by her father. In Guatemala, she was tortured, beaten, and sexually assaulted by multiple men. When the men abused her, they told her she was their property and was worthless. She entered the United States when she was 14 years old and was designated an unaccompanied minor. She applied for asylum directly with the asylum office, but her case was referred to immigration court for lack of nexus. She has an upcoming merits hearing in San Francisco Immigration Court. She expressed concern that her case will be denied and reports that she's not sleeping well. She was recently diagnosed with post-traumatic stress disorder. Next slide, please. So as we consider Alexandra's case, one of the things that we need to think about is the trauma that a child like Alexandra might have and the effect that trauma has on unaccompanied children. Next slide, please. And if you can click it one more time. I think a couple more times. Thank you so much. So the definition of an unaccompanied child is a minor that has no parent or legal guardian in the use available to provide care and physical custody and with no lawful immigration status. This unaccompanied child is a legal definition. So the Department of Homeland Security makes UC determinations at the apprehension stage, but it could be made later on by an immigration judge, an asylum officer, or DHS itself. And a child can subsequently reunite with a parent or turn 18, but the determination is set at the apprehension date. Next slide.
So we'll talk a little bit about trauma, and the main focus is to really talk about how it impacts unaccompanied youth. So we'll start off with trauma, and we heard from the hypothetical, they experience a lot of traumatic experiences, but really trauma is the response to an event, series of events, or a set of circumstances that is experienced by an individual as physically or emotionally harmful or life-threatening and can have lasting adverse effects on an individual's functioning and well-being. There are many sorts of events that could be considered traumatic, ranging from incidents of violence to natural disasters, and even uprooting someone from their home. Traumatic events can be conceptualized as events that are too much, too soon, or too fast, and they can overwhelm or pose a threat to one's nervous system. With a lot of exposure to trauma, it can also lead to chronic stress. Chronic stress is a consistent feeling of being pressured or overwhelmed over an extended period. In both cases, the brain is highly activated trying to manage a real or perceived threat. As you can see here from the image, it can also impact and have an adverse effect on us physically. Next slide. Trauma also impacts the brain. And I know many people in this presentation might be very familiar with the concept of how trauma impacts the brain. But some of the main things that we really want to point out is how it impacts the parts of the brain that are responsible, for example, memory, differentiating the past and the present. And that's, for example, the hippocampus. When the brain is triggered, the it limits the brain's ability to process and to learn, and it can have a significant adverse effect over the long term on a child's brain and impact their ability to remember things and to tell their stories in a linear way, which is something that we encounter when we're working with clients in their legal cases. So that is one of the main things that we really want to point out, and how trauma can impact the brain of a child that you might be working with. Next slide. To our particular population of unaccompanied children, it's important to be mindful that they've been exposed to many series of traumatic experiences, many stressful events that can happen pre, during, and post migration. And these events can heighten their vulnerability, have harmful effects on their development, can cause psychological distress, and impair their ability to form trusting relationships. I really like this image here because it does a really it's a really comprehensive way to see many of the different adverse and stressful experiences that unaccompanied children are exposed to, um, from pre-migration, during migration, and even post-migration. It also does a really good job at showing their resiliency factors. So we always want to talk about children in a way that we are mindful of their trauma, but also acknowledge that they're also very resilient, and that trauma can impact people in very different ways. And children, especially, might feel trauma differently than adults. So these are all things that we really want to be mindful of as we're working with children on their immigration cases. Next slide. I really like this chart here because it also shows the developmental impacts of trauma. And one thing to really be mindful of is that a child's chronological age might not align with their developmental age because of trauma. So we see here some of the impacts that trauma can have. And it's really important to kind of see, one of the main things I like about this chart is that it shows that children who experience trauma between the ages of 0 to 5 experience it more through sensations and feelings, and often internalize that trauma or those behaviors. So it can really show up as self blame and depression. However, school age children and older have explicit memory, and they can demonstrate their impact in more externalized behaviors, such as aggression, acting out, risky behavior, and substance use. I'm sorry, I don't know if you guys can hear my children screaming. um, but this is really something that we want to be mindful of, and I think this chart is helpful. You guys can review it as you're working with kids, so that you guys can see at what stages and how that trauma might be impacting them. Next slide.
Okay, so keeping that in mind, now we're going to discuss the importance of trauma-informed learning. Obviously, considering the impacts of trauma, like America just mentioned, is really important in integrating that knowledge when we're representing unaccompanied youth in their case. Next slide, please.
So again, when we're talking about being client-centered and child-centered, we really want to have that acknowledgement that unaccompanied children, despite all the adverse experiences that they face, are also very resilient. And research has shown that their ability to reach the United States, despite all of the challenges that they face along the journey, reflects their individual resources and strengths to draw upon, such as like their belief in a higher power, their grit, and their determination. They also really benefit from having extended family systems, peer groups, cultural wealth, having an attorney, and even being connected to community based organizations. So you can see that you can actually play an active role in their healing and promote that ability to continue being resilient. So we really want to be mindful of that and check ourselves so that we don't get into rescuer or hero roles with youth, and really make them a part of the process and understand that they're the drivers of their own journey and we are there to guide them and support them. So just really want to be make sure that we have that in the back of our brains when we're working with these kids. Next slide.
Okay, thank you so much, America, for that. So the importance of trauma-informed lawyering. So what exactly is trauma-informed lawyering, considering everything we've learned this far? So trauma-informed lawyering is an awareness that trauma refers to the intense physical or emotional responses our bodies may have due to an event, series of events, or systemic structures. It's a recognition that our client's trauma is likely going to manifest itself in the immigration case, and that our work as immigration attorneys is to recognize those signs of trauma and then integrate our knowledge of trauma and its impact into our services to reduce re-traumatization, build client trust, and provide holistic immigration services. And then take all of the work that we're doing and then advocate for trauma-informed practices to be implemented in the courtroom. Next slide, please.
So with that in mind, we often hear about trauma-informed care, trauma-informed approaches, and there's a lot of different frameworks for this. But I think it's important to note some of the six guiding principles that really drive this type of care or approach to our work. And one of them is that we ensure the physical and emotional safety of the clients that we're working with. That we also try to promote trustworthiness, that we try to be transparent with the goal of building and maintaining trust for everyone, that we are promoting peer support, utilizing their stories and their lived experiences to promote healing, that we are collaborative with them, that we are empowering them, giving them voice and choice, and recognizing their strengths, validating them, and finally, acknowledging cultural, historical, and gender issues that by actively moving past our own stereotypes and biases and offering inclusive spaces. Next slide. So, and you can click it a couple times. So why a trauma-informed approach? You can click one more time or two. There you go. Why a trauma-informed approach? The main thing is that we want to do cause the least amount of harm possible. We want to not re-traumatize our clients. So what does re-traumatizing mean? It means a situation, attitude, interaction, or environment that replicates the events or dynamics of the original trauma and triggers the overwhelming feelings and reactions associated with them. Like we mentioned previously, unaccompanied minors have faced so many traumatic situations pre, during, and post migration. And now, here in the United States, they might also be interacting with systems and policies, procedures that where they constantly have to retell their stories. They feel like they're being treated as just another number. They're being labeled as, a traumatized youth or a youth with problems, and they don't often have a lot of choice in those systems. They also sometimes are involved in some of these relationships with peoples from these systems that make them feel like they're not being seen or heard. and that make them feel like their trust is being violated, that they don't have a lot of power. And so we want to really aim not to reinforce, not to uh, repeat this, but really try to avoid this. Next slide.
Okay, so now we're going to give, with that background in mind of trauma and its impact on unaccompanied youth and the foundation for trauma informed lawyering, I do want to touch base on the legal framework for family and gender based violence claims because we do see these claims to be really difficult. Particularly with respect to the amount of violence and that can be contained in these claims. So, we're going to be touching on Alexandra's case when I'm mentioning the legal framework and figuring out how best to support a client legally through these types of different particular social groups. So next slide, please. So the standard for asylum, I'm sure everyone on this presentation has a basic understanding of how to establish asylum, but really quickly, in order to establish a claim for asylum, we must show that a client suffered past persecution or has a well-founded fear of future persecution by either a government actor or an entity or an individual that the government cannot or will not control. And it has to be on account of one of the 5 protected grounds, which is race, religion, nationality, political opinion, or particular social group. Next slide, please. With family and gender based claims, we are in the particular social group land, essentially. And to establish a particular social group, one must show that the particular social group has or is an immutable or fundamental characteristic, is socially distinct, and is particular. With respect to immutability, that is a common characteristic that members of the group cannot or should not be required to change. With the respect to socially distinct, it means that the group has to be perceived as a group by that society. And with respect to particularity, it means discrete, definable boundaries. It can't be so amorphous that it loses its meaning entirely. Next slide, please. So on this slide, I have a timeline of really seminal cases for gender-based claims. And we could go through this and spend just an hour talking about the history of gender-based claims, but I do want to talk about where we're at right now. So in June 2021, AG Merrick Garland noted that matter of AB1 and AB2 were vacated in its entirety, and that matter of ARCG and prior AB1 precedent should be applied. And just as way of background, matter of ARCG was a BIA opinion that held that the particular social group married women in Guatemala who are unable to leave their relationship is cognizable. Next slide, please. To break this down just a little bit further, so on this slide, I have really helpful case law that you can utilize to show that gender-based claims meet the standard for a particular social group. So with respect to immutability and particularity, you can use matter of ARCG and Perdomo versus Holder. The Perdomo versus Holder is a Ninth Circuit decision which recognizes that women in a particular country, regardless of ethnicity or clan membership, could form a particular social group, and that size and breadth of a group alone does not preclude a group from qualifying as such a social group. With respect to social distinction, I highly recommend using Enriquez versus Holder to ground your argument. Enriquez versus Holder is another Ninth Circuit opinion which states that legislation addressing a specific group of people is among the best evidence that a society recognizes a particular class of individuals as uniquely vulnerable. So in a case such as Alexandra's, what I did was I made sure to review all the law I could in Guatemala to see if there were any particular laws targeting women. So for example, was there a femicide law? Were there programs that the government is funding to address the violence that's happening against women? And using that to show that the government itself recognizes these women as a group of people. So this is a way that you can bolster your claim that gender-based claims are particular social groups and they're cognizable. With respect to nexus, courts have held that a motive is a central reason if the persecutor would not have harmed the applicant if such motive did not exist. And I found this Ninth Circuit opinion really helpful in Alexandra's case. The court noted that there were several pieces of evidence that indicated that the respondent was likely persecuted on account of her gender. Sexual violence, The fact that the persecutor singled out female captives for specific forms of harm, and that the captors used gender based slurs while sexually assaulting the respondent. So, in Alexandra's case, when I was working with her, I really tried to understand if the people that were being trafficked were solely female, and what insults were the persecutors using against her, and were they gender based? And then obviously the sexual violence that she disclosed met the standard under Velasquez Martinez for that first prong for establishing nexus. So definitely look at this opinion. If you're not in the Ninth Circuit, try to see if there are any decisions in your circuit that clearly highlight how you can meet nexus, and then present that case in court to show that you've met that standard. Next slide, please. So very similar to the gender-based slide, I have a history of very seminal case law with respect to family-based claims. We can also spend an hour talking about the evolution over the past over the past decade of family-based claims, but I will talk about where we're at right now. So in 2021, Merrick Garland vacates LEA2 in its entirety and basically says that this decision that was held before, which was that family-based groups were going to make it was going to be difficult to meet the social distinction requirement, was no longer good law, and that it was inconsistent with several other courts of appeals, which basically opened up family-based PSGs to be cognizable again. Unfortunately, in 2023, we had a very difficult decision come out with matter of MRMS, which did not touch on the cognizability of family-based particular social groups, but it made it more difficult to establish nexus in family-based asylum claims. Next slide, please. So again, on this slide, I'm including case law that you can utilize when you're preparing claims to show that family-based claims meet the immutability and social distinction requirement. With respect to nexus, we have the same standard, so that central reason standard. But now I want to turn to some ways in which you can argue that your case is either analogous to matter of MRMS, or other ways that you can try to show that you meet the nexus standard even with this decision from the BIA. So like I said in the previous slide, matter of MRMS did not touch on the cognizability of family-based particular social groups. It focused on nexus. And this decision essentially stated that to be successful in an asylum claim based on family membership, an applicant had to demonstrate that there was animus against the family. So in your own claim, as you're building a family-based claim, try to assess whether or not there was animus. If there's not direct evidence, consider using circumstantial evidence. The decision also notes that one possible way for an applicant to establish nexus for family PSGs is by showing the harm is connected to another protected ground, such as political opinion. I recently argued matter of MRMS in immigration court, and what I did was there's a decision Perez Sanchez cited in matter of MRMS, and this is a very favorable opinion because this decision stated that the animus towards the family member was intertwined with the harm that the client suffered. And so it had almost a but-for analysis, which we were using prior to this matter of MRMS decision coming out in 2023. So definitely consider analogizing your case to Perez Sanchez. I did that in immigration court, and the judge said that that was sufficient and that my client had met the nexus requirement. So definitely look at Perez Sanchez and see whether you can make your analogize your facts to the facts of Perez Sanchez, and absolutely review case law in your circuit for any other arguments that you can make. Next slide, please. Okay, so with that legal framework in mind, as you're preparing for a merits hearing, there is several pieces of evidence that I recommend that you gather. Next slide, please. So this is definitely not an exhaustive list, but these are the types of evidence that one typically compiles for a merits hearing. If you look at the written materials, I included a lot of exemplars for these types of evidence that you can utilize in your case to strengthen your client's position. I also included a merits hearing checklist, which identifies a schedule in which you should gather this evidence. And this schedule was developed with the idea that we shouldn't rush the preparation of these cases to the extent that we can to just keep a more trauma-informed approach. Next slide, please.
So thank you, Amanda, for all that. That's lots of great information. But one thing that we want to get back to is as you're compiling evidence and you're preparing to interview your clients and work with them more closely on gathering all this information and having these really difficult conversations, one key part of trauma informed care and approach is having insight to our own belief systems and trauma narrative. It's really important that we take time to regulate ourselves and address our own wellness before we even start having interactions with clients. Some sample questions that you can ask yourself as you're preparing to start meeting with a client is what is your current emotional state prior to the meeting? What assumptions are you having about the client and how can that impact your meeting with them? What are your own personal triggers and how might they be raised while you're compiling evidence? What will you do if you are triggered by a topic at the meeting? And how will you support your client and yourself during a very difficult conversation about trauma? So, really think about this before you even start engaging with the client. Next slide.
Definitely. So one of the things I do as I'm starting to compile evidence, I always explain to the client what what evidence I'm seeking and why. I think the why is really important because as you're working with unaccompanied children, they might not understand why you're asking them such difficult questions about the trauma. And these are obviously very painful things that they might not have disclosed to anyone else before. So definitely explaining why you're seeking it is really important. I always also stress and I reassure the client that it is okay if they do not have all the evidence I'm asking for. I know many clients have a lot of anxiety that they don't have direct evidence of the harm and they feel like they're going to lose their claim as a result of that. And so I always try to level set and just say that it's okay if they don't have all of the evidence, that we're going to build the claim slowly and that's fine. Identify a medium and time in which it's best to meet with the client. I've learned with clients, not everyone has the same way of expressing information. For example, a client might have a really hard time verbalizing that they were abused. And so I might ask a client whether it's easier for them to write something out, if it's easier for them to draw it, if they like talking about this while we're outside. So just identifying a medium that works for the client. I always try to build a space for the client that's welcoming. I love to have food, drink. I know America's going to talk about it later in the presentation. I try to have therapy tools available for the clients to utilize. I always remind the client that the information they're sharing is confidential and that we have an attorney-client privilege that obviously is very strong and that this information I'm solely using to help them in their immigration case. I highly recommend always creating space for breaks and having multiple meetings if the client is struggling to talk about a subject. I don't like to view this as a race of any sort. This is an opportunity to get to know the youth, to develop a relationship with them, and make them feel supported, possibly for the first time in their life. So, definitely really important to just take your time with these cases, especially if the client is struggling. And then always validating what the client went through. I always like to make sure that I take the time to tell them that what happened to them was wrong and that they weren't to blame for it. And I spend time really trying to raise self-esteem in meetings if that's necessary. So and viewing that as very integral to the actual case itself. And then, particularly with difficult meetings, you always want to end the meeting on a positive note, learning about the client, figuring out what their likes are, what they're interested in, what they're passionate about, or ending with a grounding exercise if they would like to join you. Next slide, please.
Okay. So, as you're preparing to start interviewing your client, one thing that we really wanted to show is this really helpful tool from the National Children's Advocacy Center. And this graphic, what it does is that it shows you sort of like at what age children are sort of able to answer concrete questions versus abstract questions. And it gives a good breakdown of what a concrete question looks like who, what, where, how many times, versus an abstract, which is more how, the sequencing, when, sorry, and the number of times there. But one thing to be considerate of as we're talking about trauma and everything is that, again, a child's chronological age doesn't always mean the same developmental age because of the impact of trauma. So, this is a helpful tool when you're formulating your questions for an interview, but also be mindful of that it might differ between clients based on their developmental age and their impacts of trauma. Next slide. Thank you. This is more just as a reference, as a tool for you guys. I recommend maybe even printing it. I think it's helpful. It kind of breaks down what are some best practices before, even building the starting the interview. It's really important to, as Amanda mentioned, build the rapport with the client. Start with simple questions. Make sure that you're not, that you're respectful, that you're not coming off as giving off pity, remembering that clients are resilient, that consent piece, always letting them, asking them, is it okay if I ask you about this? Creating that safe space that Amanda talked about. And then, during the interview, going into taking breaks, using open ended questions, using therapeutic tools if they're helpful. And then during the closing interaction, like she mentioned previously, making sure that you don't end it on a very, neutral topic, ending it on a positive note, suggesting some grounding techniques for them. Next slide. Sometimes we see challenges and there's some suggestions on reframing. So again, another kind of tool for you guys, for example, if a client shuts down, what are some possible reasons that the client is shutting down? It could be that they're feeling triggered or overwhelmed, they're feeling shame or afraid. And so we recommend, taking a pause, asking them if they want a break or maybe some water or a snack, changing topics for a while, or using other helpful tools that can help them tell their story, such as drawing or writing. When a client isn't being responsive, it could mean that maybe they haven't built enough trust. They have a lack of access to respond, maybe not access to a phone, or they could be focused on basic needs. It's very hard to think about your legal case if you are having trouble with knowing if you have a safe space to sleep in that night, or you don't have food for that week, or you don't know how you're going to get to your immigration court. There's many possible things that could be going on. So maybe, building that report and asking them if you have a social services team at your organization, referring them to your social services team. This is one really important part of having holistic services as agencies and really leveraging that multidisciplinary support for the youth, where you have the social work team and your legal team really working with each other to support the youth. So this is one area where it could really be helpful. Again, if a client is not following through with tasks, asking them potentially, what's going on. Maybe they're not ready. Maybe they don't feel like they want to talk about a specific thing, and or they don't have like, it could be that they have to go get their fingerprints done and they're really afraid. There's some traumas, there's some triggers. Maybe offering someone to go with them, alleviating some of the stressors that could be preventing them with following through with the tasks. So that's just some tips that might be helpful for you all. Next slide. Again, we did share in the materials some grounding tools that we found helpful. We pulled those from the internet, so they're available to anybody. But at Kind, we also use these therapeutic toolkits. We have several tools that we use during, for example, Know Your Rights presentation, intakes, meeting with clients one-on-one, and these can be very helpful. Amanda can speak to how useful they are during presentations, and they could be very simple. It could be crayons. We shared some mandalas that are in that those tools that we shared. Those could be even helpful while you're having conversations with your client. If a client is having anxiety, those can help them. Stress balls. So those are tools that you can use that we also thought could be helpful as you're preparing clients or you're meeting with them for any types of preparation for their merits hearings or anything else. Next slide.
Okay, the therapy toolkit is truly fantastic. We will definitely talk about it more when we get into like actually prepping for immigration court hearings. But I did want to take some time to provide additional considerations for working with Indigenous and/or Afro-descendant women. So, due to the many levels of oppression that Indigenous and Afro-descendant women face, they are more susceptible to gender-based violence. And you should absolutely include country condition articles that highlight the intersecting prejudices that race and gender have and how these groups of women are more susceptible to violence. And they have been more susceptible to gender based violence because of imperialism and colonialism in Latino America and this battle over the ownership of territory, including land and women's bodies. When you're working with Indigenous and/or Afro-descendant women, consider inquiring about their lived experiences and how it differed for other women who did not identify as such. And one thing I find really important is also making sure that we're using terms that they identify with. For example, many of my clients do not identify as Indigenous. They don't understand what that word is. So making sure that you're using terminology that they identify as, using that in your briefing, presenting that to the court, avoiding homogenous characterizations of these women. These women don't have one lived experience. None of us have one lived experience. So making sure that we are being mindful of that and inquiring what specifically happened to them and what was their experience and letting them lead their story. Next slide, please. So I do want to take some time to discuss supporting declarations. I have found that it is sometimes difficult for family members in home country to provide a supporting declaration because they're fearful. So explain one of the things that I do when I'm working with family members who are in home country who are afraid is I always explain to the witness why I'm seeking to draft a declaration on their behalf and how it will help the client. We talked about medium a lot earlier in this presentation, and I always try to devise a medium that makes them feel comfortable. So, for example, I might say to the client, to the witness, I don't need to send the declaration to your phone. I can read the declaration verbally. So, for example, I can type it on my computer and then I'll translate it to Spanish and then I will verbally read that to you so that there's never a declaration on your phone. I have found that some witnesses are afraid that their phone is either tapped or could be stolen and that that declaration being on there could actually be dangerous for them. So I do try to identify different mediums. I always create space for the witness to share their concerns and walking through those concerns with them. I think a lot of the witnesses are afraid that that information could get out, that it could be published. They're used to systems being very corrupt. And so I try to tell them that their declaration is confidential and that it won't be shared outside of the immigration case. It won't be published anywhere that could be danger to them. And I always make sure to translate that declaration in their native language. I review it with the witness and ensure that there are no corrections needed so that they feel that this is their declaration, they're leading it, and it's not that I'm trying to insert words into their own declaration that shouldn't belong there. Next slide, please. So client-centered strategies when working with experts. This is a really important topic because there are definitely ways that we can collaborate with experts to make sure that they are also working with our clients in a trauma-informed way. Next slide. So when I'm working with experts, before I even reach out to them, I communicate with the client the reasoning for why I'm seeking an expert. So for example, I might tell a client, we need to prove that you cannot return to your home country and how dangerous it would be. So I need a country conditions expert, and I'm going to share your declaration with them if that's okay with you. And making sure to get their explicit consent to do that. So one of the things that America mentioned earlier in this presentation is that the clients are the drivers of this case, and we are just in the passenger seat. And I truly try to model that in my representation and making sure that the client understands why I'm doing things and making sure that they also consent to that and that their story isn't being shared with anyone that they haven't given explicit consent to. I always provide a case background to the expert and I let them know if there's anything that I'm worried about with respect to the client's trauma narrative. For psych experts, I highly recommend asking them to incorporate a discussion of complex trauma in the expert declaration. It is possible that the DHS counsel you're working with has very limited knowledge of complex trauma along with the immigration judge. So making sure to incorporate that knowledge to them so that they understand how complex trauma works. And then working with the expert to identify what you're seeking to be addressed in the expert declaration is really important. So outlining what you need in the expert declaration, reviewing it after the fact, and then really stressing to your client that this declaration is going to remain confidential and that it's only being used for purpose of their immigration case. Next slide, please. So to the extent possible, I highly recommend making sure that your expert agreement is always in writing, reviewing the draft expert declaration to make sure that it does not conflict with any of the clients or supporting witness declarations. I always review the expert declaration with my client and I want them to understand the findings and its relevance to the case. I don't read it, you don't have to read it word by word. You can give them a summary if you think reading it word by word would be too difficult. But I do like to make sure that they understand what that expert declaration says and why it's helpful. I prepare the expert before the hearing. I schedule prep sessions with them. I review drafts and cross-examination questions to the extent they're called the day of the hearing. And then I always tell the client if the expert is going to be in attendance, because I find that clients, generally are very nervous already, and having another person in the courtroom can be very difficult for them. So just letting them know whether the expert is going to appear telephonically, through video, or in person. And again, making sure that you always have the client's consent. Next slide. So now we're going to transition into client-centered strategies when preparing clients to testify in court. Next slide, please.
So we've talked a lot about creating a safe space, but I really want to stress that creating a safe space actually starts before you even start working with the client. And the way that you do that is by communicating with them ahead of time as to what they should expect. For example, what will the meeting be about when they come? And then making sure that you are telling them, we're going to be doing this in 3 sessions, and giving enough time between the sessions so that the client is prepared for what they will be discussing at each of the prep sessions. Otherwise, being prepared, drafting the questions before the meeting, again, creating that safe and welcoming space, offering the food, the beverages. We also recommend having the space feel more child centered. For example, you want to have things around that are not as rigid or cold. You want to make your spaces warm, check the temperature, make sure that it's not too loud, that they have space to feel relaxed. Also, that again, scheduling the breaks or taking breaks when needed, using the therapeutic tools that you have at hand, and again, always ending on a positive note. And one thing I want to mention that I think I forgot to mention throughout, I'm talking a lot about the client and taking care of their wellness and making sure that they're okay, but we don't have time for this topic because it's such a large topic. But one of the most important things for us practitioners that are working with unaccompanied children is taking care of ourselves. So the same way that you're taking care of the client, making sure that you're taking care of yourself, that you're also centered and grounded for those meetings, that you have enough tools, that you're taking breaks for yourself. And so I just wanted to mention that before we end the presentation. There's a lot of great resources out there for taking care of ourselves, but it is really important that we are well when we are working with our clients. Next slide.
Thank you so much for that, America. That's definitely very important and true and can be a whole presentation on its own. So as you're creating a safe space, I highly recommend having 3 preparation sessions prior to a merits hearing. And like America said, I try to space them out to avoid it feeling like a race and exhausting the client before the court date. So I try to outline how I structure the prep sessions and how I found that it works best. So during the first preparation session, I try to keep this a lighter meeting. So this is the first time we'll review the direct examination questions. I'll explain the courtroom, the layout of the courtroom, what they should expect the day of the hearing. I try to identify things that will help the client feel at ease and supported at the day of the hearing. So I will ask them, what do you think of when you're stressed that helps you calm down, and try to make sure that we start learning how to ground ourselves the day of the hearing. When I'm reviewing the direct examination questions, I'm just making notes of ways in which I can word questions better so that the client can understand what I'm seeking. And I confirm the date and time of the second preparation session. I don't do any cross on the first preparation session. This is just an introduction essentially to what they are going to go through in immigration court, but it's not meant to be very heavy. Next slide, please. The second preparation session, I would say, is the meatiest of them all. This is where we will do a pass through of the direct examination questions with particular emphasis on those that they struggled with, and we'll do a mock cross. Because this is a meatier session, I definitely incorporate a lot of breaks. I'm making sure that we're taking time to stop and talk about other things besides the actual prep. We do grounding techniques. I make sure to always have therapeutic tools available at each of these preparation sessions. And I'm very intentional about making sure that we're learning those grounding techniques and we're identifying a way to make sure that they're okay the day of the hearing. And I always end on a positive note or a grounding exercise, just because the second preparation session can be heavy with the mock cross. Next slide, please. The third preparation session, I would say I always keep it light, and I'm focused on validating the client. So I'm focused on making sure that the client feels emotionally supported and understands that they're the expert in their story. So there's no one who knows the client's story and what happened to them better than the client. And I really like to remind them of that, because at times DHS could start gaslighting clients and making them question their own story. And I really try to make sure that they understand that you are in control. This is your life. This is what happened to you, and feel confident in expressing that story. I focus on building a positive and hopeful tone with the client. I address any concerns the client may have about their immigration case and what may happen if the judge denies their case. And I reiterate the schedule for the day of the hearing. If we address any questions, it's just those questions that the client might have a particular issue with. I'm not doing a full pass through of the direct during the third preparation session, and I'm not doing a full pass through of the cross. The reason why is because the third preparation session is usually close to that court date, and I don't want to exhaust the client or make them so fearful that they just are not, they don't feel confident walking into the courtroom on the day of their hearing. Next slide, please. So now we're going to discuss, we've learned all of these great techniques, this wonderful knowledge with respect to trauma that America shared with us, and ways that we can implement these trauma-informed practices in our work. And now I want to discuss about advocating for unaccompanied children in immigration court. Next slide, please. So it's really important to remember that for children, the level of harm required to meet the standard for persecution is less than that of an adult. And I always make sure to remind judges of that if we're working with unaccompanied youth who suffered this harm when they were either a teenager or a tender age youth, I always remind them that that level of harm has to be viewed from the perspective of a child. I also utilize matter of MAM pretty frequently in cases where I'm arguing where the judge should apply appropriate safeguards or accommodations. And this is a great decision where the board recognized situations where even if an applicant was found medically competent, an immigration judge could still apply appropriate safeguards and accommodations. I highly recommend doing a grava motion. So grava versus INS was a Ninth Circuit opinion, which allowed respondents to forego testifying under direct examination and rely solely on their application and declaration in support of their application. So for example, if you're working with a client who has a really hard time verbalizing their trauma, if every time they talk about it, they start sobbing, it becomes very difficult, and you feel like this is going to harm your client by forcing them to do a direct examination and possible cross, definitely consider doing a grava motion. particularly if you're working with a tender age youth who's in immigration court or a teenager who's in immigration court whose case was referred by the asylum office. Next slide, please. There are varying levels of success with this, but I highly recommend reaching out to the ACC assigned to the case beforehand to see whether or not you can limit issues. In Alexander's case, I reached out to the ACC and we were able to limit testimony prior to the hearing. So, for example, the ACC agreed that my client did not need to testify about any of the sexual abuse that she had suffered and that we were solely going to focus on nexus. If the ACC doesn't agree to limit testimony in your case or doesn't even respond to your email, I would still, at the outset of the hearing, inquire the judge's position on the case. Hopefully, they've reviewed all of the materials and have an idea of where they land on certain issues and try to advocate to limit issues at that stage as well. So don't feel defeated if the ACC themselves won't agree to limit the issues. Also push for the judge to do so and to take control of the courtroom to protect your client. I always recommend objecting at the hearing. I put some sample objections here. I do want to highlight one because I think that this is very important. If opposing counsel is being argumentative and there are physical things that they're doing that are not being reflected on the record, such as pointing their finger, banging the table, rolling their eyes, I would object to opposing counsel being argumentative, but I would take it a step further and include the fact, I would say, objection, Your Honor, argumentative, opposing counsel is pointing their finger, opposing counsel slamming the table, rolling their eyes, just so that that gets in the record and you're able to show what the feeling is in the courtroom and what the energy is and how could that impact the client and their testimony. Next slide, please. I highly recommend that you all utilize the EOIR Director's Memorandum for Children's Cases in Immigration Court. This recently came out of December of last year, and it's absolutely fantastic. It touches on different ways in which we can advocate for youth in the courtroom. So with respect to credibility, it states that immigration judges should recognize that children, especially young children, will generally not be able to testify with the precision and clarity of an adult. It advocates for courtroom modifications to be implemented and directs immigration judges to make those courtroom modifications if it would make a child feel more comfortable. And then there's a whole section around child-sensitive questioning. And the recommendations from the court are to use short, clear, age-appropriate questions and sentences to avoid the use of technical terms such as persecution. And then it recognizes that we shouldn't expect children to be immediately forthcoming about events that have caused great pain. And it states that imprecise date and time recollection may be common for children, which it's great to see a director's memorandum from the court instructing immigration judges to keep this in mind as they're working with youth, because this has not always been the standard, and it's great to see judges being trained in this way. Next slide, please. Okay, and so now I'll open it up to questions. I don't know how much time we have for questions, but I think about 5 minutes or so.
We have maybe 2 to 3 minutes, but we can see what we get through and go from there. I can read out some of the questions that came in. So the first question is, do you possibly have a citation reference for the chart you have on slide 12 relating to the developmental impacts of trauma? That was really helpful.
I don't have one on hand, but I will try to get that. And maybe I can share with you guys, Serena, and update the PowerPoint.
Yeah, absolutely. So the slides are already shared and available for you all to access, and we can maybe update it with the citation for that one, just so that folks can reference it directly. There's another question on one came in the chat. Any suggested alternatives to using the term or Indigenous?
Yeah, so usually so some clients will say I am mom, I speak mom. And so making sure to reference the fact that they're identifying as mom or kick she and using that term versus if you were just directly ask the client whether or not they're Indigenous, they might not understand that. term because that's a term that we use here in the United States. And so being just mindful of the way that you're classifying them and being respectful that they might have a different way that they identify that is the term that they use in their community that feels right for them, and just using that in the briefing. And I think also Ana Moraga, I saw in the chat, uh, shared a linguistic map that I highly recommend that everyone utilize as well.
Great, thank you. And the last question is, how do you avoid re-traumatizing clients when working on their affidavits?
That's a wonderful question. I think tone is really important, and being mindful and validation. So validating what your client went through, expressing to them that this process is really unfair. I'm really honest with clients that I wish I didn't have to take a declaration from them and outline all the harm that they went through, that I'm a perfect stranger to them and that I don't deserve to have this story, but that we're doing it to help their immigration case so that they can be safe. So I think having very, empathetic honesty, being open with your own feelings about the process makes the client feel more secure. I think it's the client usually will understand that this is part of the process. Utilizing those therapeutic tools and making sure that the space is welcoming will go a really, really long way in minimizing the re-traumatization of the client and having to share this story with yet another person.
Really appreciate that. Very thoughtful response. There's actually one more question I think we can fit in. What are your thoughts on not including a client declaration with the I-589 or including an unsigned declaration just to avoid to lessen the likelihood of a client contradiction at the asylum office interview?
So I recommend including a declaration and you can have it signed. I think with respect to contradictions, I think one of the things where clients get tripped up on, and this is very normal. I too would have a very hard time recollecting dates and remembering dates, is never to use an exact date. I think that that could be very hard for a client to remember years down the line if their case was referred to immigration court. So I always try to couch dates with seasons. If the client remembers an exact date and that date is it's very clear in their mind, that's fine. But I'm usually very hesitant to include an exact date unless that client can tell that date to me several different sessions, the same exact date, and have no hesitation that they will not remember. That's usually the only area where I see clients having difficulty is with remembering dates, not so much with remembering what happened. Generally, clients are fairly clear on that. And if you're seeing that clients are having memory and trauma issues, definitely do a psych eval to see whether or not that trauma has impacted their memory and rely on a grava motion so that the declaration stands as is.
All right, thank you so much from me. Those are all the questions. I'll hand it over to Marisa to introduce the